first question I'm going to ask you is a difficult one. I assume that a lot of you here have kids. So what would happen if something were to happen to you and your kid is staying at home with a nanny? What would happen to the kid? The reality is that the police officers are going to come to your house and they're going to ask, are there any families around to pick up the kid? And if not, then the police officer is going to send the kid to Child Protective Services. And in Child Protective Services, the kid is going to mingle with a bunch of strangers until when the judge appoints a guardian. And that could be 6 months, that could be God knows how long. And this is just the short term. In the long term, you're going to wait for the judge to assign and appoint a guardian. And guess what? How is the judge going to decide? The judge doesn't know your family, and the judge is just going to look on the paper. For example, my sister and my sister-in-law. My sister-in-law, looks great on paper. Like she's married, she has kids of her own, and she has a stable job. And my sister is only in her 20s, and she's not in a relationship. She doesn't have any responsibilities. If you were the judge, who would you pick as the guardian of my kids? Sister-in-law or sister? Right? Right. But I would much rather to have my sister be the guardian of my kids, because my sister is one of the most compassionate person I've ever met. So, that's what's going to happen if you don't have a plan in place. And third, you also want to think about who you do not want to name as your guardian of your kids. A few years ago, there was a court case. Mom died, leaving dad and grandma. Dad said, "Grandma, you can't pick up the kids anymore. You can't visit the kids anymore." Dad said, when mom was alive, he and mom agreed that if something were to happen to her, grandma would not have access to the kids. But is that true? Well, you have no way of finding out because nothing is on paper. And so what the judge is going to do is to see what the dad has to say. And so if you have one of these issues on the purple sheet, you can check the box next to I need a kids protection plan. In my office, what I do is to help my clients prepare a kids protection plan where I help them name temporary and long-term guardian. And I also have a little ID card that I help my clients to prepare for, and I'm going to pass this around and you can take a look. This plan is sufficient. If you have minor children and you have assets about $150,000, this should probably be sufficient. Those people who have named guardians, in my experience, have made one of the 6 common mistakes. Mistake number 1 is naming only one couple as a guardian without thinking about what's going to happen if they were to divorce or one of them were to, pass away. The second thing is only name one guardian without thinking, without having any backup. The third one is only consider financial resources without thinking about the personality of the guardian to take care of your kids. The fourth one is only having a will, which means that the court will have access, will be deciding what to do with your money. And the fifth one is forget to exclude certain people that you do not want to be your kid's guardian. Mistake number 6 is only naming guardians for the long term without making any arrangements for short term. For example, if you have relatives, your really close relatives in a foreign country, and something were to happen to you here, who's going to come and take care of your kids in that meantime, in that time? So now I'm going to move on to what's going to happen to your money in case something were to happen to you if you have assets more than $150,000. Your assets include your bank account, your brokerage account, your retirement account, and your life insurance policies. If you have assets more than $150,000, it's going to go through probate. Probate is a legal proceeding to move your assets from you to your heirs. It's a very time-consuming process. The minimum time requirement is 12 to 16 months minimum, during which your assets will be completely frozen. Nobody has access to it. It's also very costly. I estimate roughly about like 5% of your gross estate. So for example, if all you have is a house that you can sell for about $500,000, the probate fee alone is going to be $25,000. And that's not counting attorney's fees and executor's fees and etc. And if you have children under 18, your asset is going to go into a guardianship estate. So the judge will take charge of that money for you, appoint someone to take charge of the money on behalf of your kid and distribute it outright to the kid as soon as the kid turns 18. And for those of you who have kids, you probably know that kids who are 18 are probably not the most financially savvy yet. But the money is going to go immediately to them, subject to predators, and it's completely public. The worst part of this whole tragedy is that it's completely voluntary. Probate is only for families who do not plan in advance, and you could totally avoid it by planning in advance. So if you have assets above $150,000 and you think it might occur to you, check the box next to I need to avoid probate on the purple sheet. Life insurance is actually not included in your entire calculation of the probate, but if you name a beneficiary on your life insurance and the beneficiary is under 18, then that amount of money could go to probate because kids under 18 cannot hold assets. So if you name if you name a beneficiary who's under 18, you need to check the box next to I need to avoid probate. All right, because that could be an issue. Currently, the most current law in 2015, the state tax exemption is $5.43 million. And you're gonna think, okay, that I still have a long way to go, But what that means is, if you have assets more than $5.43 million, anything above that is going to be taxed at a 40% rate. So 40% of that is going to go to Uncle Sam if you don't plan in advance. And one thing I need to caution you is that even though the exemption amount is really high this year, the thing about IRS is they love changing their rules, and they change their rules every year. So you don't ever know if they're going to lower the exemption amount next year or not. They could lower the exemption amount to like $1 million, and you could reach that amount if you have $500,000 of house plus $500,000 of life insurance, which is very likely for most families. And so my office usually meets with my clients every 3 years to make sure that their assets, their lives, and the law are all in place to make sure that their plan actually works when they really need it. One thing I need to mention is that life insurance is included in calculation of the estate tax. So I gave you a lot of general information. You're going to say, oh, so how does that apply to me specifically? I suggest that you find out. And in my office, I usually have an initial family wealth inventory assessment. Before the meeting, I will give you an assessment sheet where you'll fill out some information, and when you come in and sit down with me, I will go through all your options with you and discuss what's going to happen to you under your current situation and what are the options for you, to plan in advance, so to avoid all the things that I was talking about. And the whole idea and the whole process is for you to make empowered, informed decisions, to protect your families and to protect your loved ones.